We can show you how.
Live streaming can be simple and not expensive. You may already have the basic tools right in your hand. But it's more than just pushing live to communicate effectively. That's where Yuba-Sutter.live and Live Streaming YS on Facebook can help you. Make it easy to jump in. Just give us a call at 530-301-2931 or visit our website, www.yuba-sutter.live. Yuba-Sutter's home of live streaming and live streaming tools, live streaming services, technology, and training. Live streaming is Yuba-Sutter.live.
All aboard!
We can show you how.
Live streaming can be simple and not expensive. You may already have the basic tools right in your hand. But it's more than just pushing live to communicate effectively. That's where Yuba-Sutter.live and Live Streaming YS on Facebook can help you. Make it easy to jump in. Just give us a call at 530-301-2931 or visit our website, www.yuba-sutter.live. Yuba-Sutter's home of live streaming and live streaming tools, live streaming services, technology, and training. Live streaming is Yuba-Sutter.live.
can show you how.
Live streaming can be simple and not expensive. You may already have the basic tools right in your hand. But it's more than just pushing live to communicate effectively. That's where Yuba-Sutter.live and Live Streaming YS on Facebook can help you. Make it easy to jump in. Just give us a call at 530-301-2931 or visit our website, www.yuba-sutter.live. Yuba-Sutter's home of live streaming and live streaming tools, live streaming services, technology, and training. Live streaming is Yuba-Sutter.live.
you how.
Live streaming can be simple and not expensive. You may already have the basic tools right in your hand. But it's more than just pushing live to communicate effectively. That's where Yuba-Sutter.live and Live Streaming YS on Facebook can help you. Make it easy to jump in. Just give us a call at 530-301-2931 or visit our website www.yuba-sutter.live. Yuba-Sutter's home of live streaming and live streaming tools, live streaming services, technology, and training. Live streaming is Yuba-Sutter.live.
The only way we could possibly do that is at a pool with a bar on a sunny day.
Well, I could suppose do that up at the lake with a houseboat or two.
Don't
You can
tell
always
me.
go out to our duck club.
We're in 10-minute time. What am I
Right.
talking
Yeah.
about?
I'll restart the recording, Mr. Chair.
Okay.
This meeting is being recorded.
Okay, we're back from our break between closed session. We have a 11 o'clock item, which is receive a high-level overview of the Agency Act. I think Terry's going to cover this, sir. Dick?
Before we move on, let's let the record reflect that during the closed session, there was no reportable action.
Okay. Will that cover our report out?
Thanks, Dick.
Yes.
Okay. Thank you, Dick. It's your show. Richard?
Do you guys want to proceed with this now, or would you like to defer it to a later meeting? I'm not sure there's any time sensitivity for this except for the new directors.
I would
I'm
like
open.
it. I'd like to continue. Okay.
Okay?
That's
I-
one man's opinion.
Continue.
Okay, that's 3. I think we got 4. So
That's fine with me.
Very good. Okay, Jim, if you want to pull up the slides. Right.
Very good.
Yeah, next one. So the staff has asked me to present for the directors a high-level overview of these subject matters. Most of my discussion will be about the Brown Act, the state open meeting law, and your own local rules. And then I'll talk very briefly at the end about some conflict of interest and Agency Act issues. Next slide. When I talk about the Brown Act, I always like to share this. This is a photocopy of the original act adopted by the legislature in 1953. It was a page and a half, and this thing has evolved substantially since 1953. It's now about 27 pages long, depending upon your version, and there's 52 separate sections. It's a favorite act of the California legislature to tweak with, and you guys are now at the receiving end of that. Next slide. A couple of points about why do we care about the Brown Act. Obviously, it's the law, and you're supposed to comply with the law. Probably more importantly, it's really good public policy. You guys are public servants, you're public officials. You are sitting on the board because the voters put you there. You're answerable to the voters and the residents of Yuba County. If you cross the line under the act, sometimes your actions can be voided by a court. If you cross the line, you can suffer criticism in the newspaper or on social media. And if that happens, then you start to lose credibility with the public. And when that happens, you can get sued. And if you get sued and lose, you pay the other party's attorney's fees. And if you really cross the line, the local DA could pursue action against you. So it's a very significant statute for the directors to be aware of and comply with. Next slide. At a very fundamental level, the Brown Act applies to meetings of a local agency, legislative body. It requires your meetings to be open and public, subject to exceptions. And there's now, as evidenced by these 27 pages, there's now very detailed rules about how to call and notice meetings, agendas, the rights of the public, closed sessions. I'm not going to talk much about that third bullet, and I'm going to focus more on some big pictures and issues and some Yuba specific issues. Next slide. So as applied to Yuba Water Agency, what's a legislative body? And there's 2 principal categories of legislative bodies. Obviously, there's the agency board, and you're meeting now in a public session. Obviously now during this pandemic, we're operating under extraordinary rules that allow for these video conference meetings. The second category are standing committees. And coincidentally, earlier today, at your meeting earlier today, you approved appointments to your suite of standing committees. Yuba Water Agency does a good job about working through a committee process, which can be a good business tool to filter items as they bring their way to the agency board. The third category are what's known as ad hoc committees. And an ad hoc committee is a committee of 3 directors or less without continuing subject matter jurisdiction or immediate. And
I'm hearing this weird noise.
Start that. Andy, you're muted. You should be able to unmute now, sir.
We need a plan B and a plan C. All right, have you got us isolated?
I think we're okay for the moment. Dick, your audio okay?
All right.
there we go. Can you hear me now?
Okay, we're good. One last setting.
That was a good example of what happens at an open and notice public meeting. So I look forward to the Zoom meetings being finished, because it's going to be a lot harder for folks to do that kind of nonsense in an open face-to-face public meeting. But getting back to the agenda or the slides, I was talking about ad hoc committees, and also coincidentally earlier today you've approved your suite of, you have a few ongoing ad hoc committees. One of the cautions about ad hoc committees is it can start as an ad hoc committee, but if an ad hoc committee continues on too long, it just by definition will evolve into having continuing subject matter jurisdiction and should either then be treated as a standing committee or disbanded. Next slide. And as I walk through the slides, if any directors have comments along the way, it's probably better to interrupt me and ask the question while I'm on that slide rather than wait to the end. So please, let's keep this informal and ask questions along the way if you have any. The next big picture issue is what's a meeting? And what's a meeting has really gotten more complicated in the last 20 years with the onset of social media and email and cell phones and all of that. And it encompasses much more than just a physical gathering of 4 or more directors. Obviously, it includes those sorts of things, whether you're in a formal meeting or more informal structure. But a meeting can also include any series of communications through old school telephone, email, social media, involving a majority of the directors that discuss, deliberate, or take action. And so you need to be cautious anytime there's a gathering of 4 or more of you. Next slide.
Dick, this is Randy. A quick question on that. So at any particular meeting, if a 4th or 5th board member wants to attend, is that permissible and under what conditions?
Yes, and that's with regard to committee meetings. It is okay for a director not on a committee to attend the meeting, but the Brown Act expressly states you will do so as an observer only, which means you must keep your mouth shut. You can't ask any questions. You just sit there and observe. And so a director can indeed participate, but it's subject to that significant limitation.
Thank you.
One of the unique issues with regard to your particular board is I'm counsel to the agency board, so I worry about you guys when you wear your hats as YCWA directors, and I deal with a 7-member board. A quorum is 4, but 5 of you are also coincidentally supervisors, and you wear a supervisor hat. And in that role, you really need to be cautious when 3 supervisors get together doing water agency business. Because of the broad jurisdiction of the county, if 3 supervisors get together informally through to talk about water agency business, you're going to run the risk that that could be construed as an inappropriate meeting of the County Board of Supervisors. So I just caution those of you who are county supervisors to be leery about anytime 3 or more of you get together, because that could be a problematic county meeting. Next slide. Serial meetings is a related concern under the Brown Act. A meeting doesn't necessarily mean a physical gathering at the same time and place like we're doing now, but it could be a thing that happens over a period of time. And the Act therefore prohibits any kind of direct communication or use of intermediaries to take care of or discuss or take action on agency business. And there's 2 concerns here. Is we sometimes talk about daisy chain and hub and spoke meetings. A daisy chain meeting is where Director A talks to Director B to C, C to D, and over the course of 3 or 4 separate conversations, you've got a collective concurrence of the majority of the board communicating views on a subject matter or discussing a subject matter, and that's a Brown Act violation and inappropriate. The related one is hub and spoke, is like a wheel where you've got somebody sitting in the middle as the hub. It may be the general manager, it may be the board chair, it may be other staff, and that person reaches out sort of one at a time to a series of directors to solicit input or views on subject matter, and that also is inappropriate. I want to contrast that with agency staff briefings, which are okay. It's okay for the GM, for example, to brief the directors outside of a board meeting, but in those situations, the GM needs to be very careful about not communicating one director's views with any other director. Next slide. So related to that is one of the primary concerns you have as directors with regard to an inadvertent Brown Act violation deals with the use of email. And most of us are very familiar with the use of email in our business life and our personal life, and it's a great business tool to communicate and conduct business. But when you're wearing your water agency director hat, it's also a vehicle by which you can violate the Brown Act if you use email or a series of emails to discuss business among a majority of the board. And that's contrasted with a one-way email. You may, for example, receive an email from the general manager or from myself, for example, sharing information to the full board. And that's perfectly appropriate to use email to communicate information. The problems arise when people start responding to that email. And my safest advice is, as a director, on any email involving water agency business, be really careful about ever clicking reply to all. because it's going to be that reply to all click that runs the risk of getting you into trouble. If you want to respond only to the sender, which it may be the general manager or me or others. That's the safest advice there. This past legislative year, we had one bill, AB 992, addressing the Brown Act. And this was a sort of social media related bill, and it did two significant things. First of all, it confirmed what is already happening, and that is it's okay for a director to use social media to answer questions or share information with the public. And it confirmed what many local agency officials and directors already do. The second bullet, though, there is a significant limitation. It prohibits a director from responding to or commenting on another director's social media post relating to agency business. So if if Andy puts something out there on Instagram supporting some water agency project, it would be inappropriate for you perhaps to even like that message. And it's a really interesting limitation, because this one is not a majority. That's just any one director responding to or commenting on another director's social media post. So for those of you who are on, and I'm not a big social media guy, but for those of you who are on Facebook and Instagram and all the others, you need to be worried about this one.
Question.
Yeah.
So Gary puts out 10 to 100 posts a day. I like one of them. I've violated this rule. What is my punishment?
I'll get to that slide. That slide's coming up. Yeah. It'd probably better if I just wait for that slide, because there's kind of a laundry list of things. Next slide. And then I also just want to reflect on what's not a meeting. Obviously, discussions among 2 or 3 of you is not a meeting unless the 3 happen to be supervisors, and that could be a problem wearing your county hat. We talked about separate briefings by agency staff. That's okay. The Brown Act also sanctions your attendance by a majority of you at public conferences, another board meeting in the county, community social meetings. All of those are okay, so long as at any of those events, 4 or more of you don't get together to talk about agency business. But otherwise, these other activities are okay. Next slide. I'm not going to spend a whole lot of time talking about closed sessions. There's quite a lot of detail in the Brown Act about closed sessions, but the one thing I want to highlight, and Willie mentioned this during our recent closed session, is he reminded the directors that closed session discussions are confidential, and that's very important. There's a firm prohibition against directors disclosing any confidential information you learned in closed session with any third party, and third party includes, colleagues, spouse, friends. You need to be very careful about that. There are some exceptions. If a director thinks there's been a violation of law, you can talk to me or the grand jury. You can express an opinion about the propriety of what happened or didn't happen in closed session. And if you learn something in closed session that's generally known, it's our public information, then it's okay to talk about that. Next slide. And so starting to get into the issue of consequences and violations, starting with what happens if I violate a closed session confidentiality. Part of the answer to the question depends on who's the violator. If the violator is an employee, because a lot of times agency staff will participate in closed session, then management should do that as a disciplinary situation and use appropriate employee discipline. If the director is the one violating closed session confidences, then that can be more challenging. And we do things like sometimes counsel the offender. Sometimes agencies go so far as to publicly censure or reprimand a colleague. It's appropriate to report violations to the grand jury or the local district attorney, or you could even seek an injunction from a court to seek violations. But this can always be a challenge, and some of the challenges with closed session violations are, it's happening, but you don't know who the leaker is, and that unfortunately has happened many times in my career. where things are slipping out of closed session and it's hard to pinpoint the offender, and those can be difficult situations to deal with. Next slide. And this sort of gets to Seth's question earlier about what happens if I violate the act. And these are the potential consequences. A violation with intent to violate it is a misdemeanor. So in a worst case, it can be a crime charged by the DA. These kinds of prosecutions are extremely rare, but they do happen. And again, these are intentional situations, not the inadvertent thing where the violation was unintended. Secondly, there can be injunctive relief to try to stop violations. Third, and this is probably the biggest area where the Brown Act is practically enforced, is an interested person can file a lawsuit. And sometimes that interested person may be local media to enforce the Brown Act. In those instances, there has to be a notice given to the local agency. And then the last consequence is there's always a risk of attorney's fees. And so again, returning to Seth's question, with the very minor inadvertent violations, the consequences are very limited and slight, if any. And probably the most significant consequence is getting one of the early slides I had is why do we care about the Brown Act? And they're probably the biggest issue I caution directors about is just credibility with the public, credibility with news media to try to toe the line when it comes to complying with the Brown Act, because you can suffer in those other arenas if an agency is perceived as a regular violator of the Brown Act or somebody who doesn't comply. Next slide. There's a really good resource out there called Open and Public 5 that's available from the League of California Cities. I have the link there. Jim can make these slides available to you, so you don't need to try to scramble and write down that long link. But that's a very good tool for those of you who are, kind of a layperson guide towards the Brown Act. A good tool. Next slide. At Yuba Water Agency, you guys have adopted detailed rules for proceedings of the board of directors. And these are local rules that facilitate public participation in your meeting, protect directors' rights, and provide for how to conduct meetings. I also have a hyperlink there to where you can find those policies on the agency website. For all the directors, but in particular for the new directors, this is one agency policy that I really want to draw your attention to, because this is one that talks about the nuts and bolts about how we run board meetings, and if there's ever an issue or a controversy, it will be a resource by which we resolve how to handle things. So that's an important document for directors to be familiar with. A couple highlights in there. The rules talk about how we select the chair and vice chair and the duties of those officers. It talks about the need for votes and significantly for Yuba Water Agency, and it's not the same with all local government agencies, but for Yuba Water, taking action as a board requires 4 affirmative votes, and that's contrasted with a majority of a quorum. So if there's a quorum of 5 directors, you have enough directors there to do business, and then there's a vote on a matter, and the vote is split 3-2. That 3-2 vote does not pass the motion. The motion would require, in the instance of only 5 directors at a meeting, it would require 4 of the directors to vote yes. One of the other unique things about Yuba Water is that an abstention is going to count as a vote in favor of the majority. So sometimes the director may wish to abstain from a matter because he or she wants to make a statement, or maybe he or she doesn't feel comfortable, knowledgeable enough to vote on the matters. So the director says, well, I abstain. In doing so, when we count up votes, it's important to recognize that abstention will count towards the majority. So the example there I have, let's say there's 6 directors in a meeting, 3 vote yes, 2 vote no, 1 abstains, that one who abstains is going to be counted with a 3, so the motion passes. And that's an important detail point if you ever abstain. The exception to that rule is if you abstain because of a conflict. That type of abstention is as if you're not in the room, so that doesn't count the same way. Next slide. So continuing, more highlights of your local rules. There's simplified rules for order in your rules, things like how to make a motion to amend and whatnot. For those of you who fancy himself a parliamentarian, the Roberts Rules of Order that some of you may be familiar with do not apply to the Yuba Water Board. So that would be inappropriate to say, well, Robert's rule says yada, yada, yada. Well, that may be well and good, but generally that's not going to decide the point. The point's going to be decided by your own local rules. There's also several provisions that go into some detail about directors' various rights and limits. The rules talk about delegate to the general manager the responsibility to prepare the meeting agenda in consultation with the chair, and that's an important delegation of responsibility. It also sets forth a director can ask the GM to put an item on the agenda, but one thing I really want to highlight is this deadline. You guys meet on Tuesdays, and if you want to get something on the Tuesday agenda, you're supposed to get your request into staff by end of business on the preceding Wednesday. So don't wait till Monday and call Willie and say, hey, Willie, at tomorrow's board meeting, I'd like to talk about XYZ. That can't happen because of notice requirements and deadlines. So that's an important mental note for directors to get that in early. It talks about how to call a special meeting. That can be called by the chair or a majority of directors. And it also goes into some detail about your committee and how committee members are appointed. And you guys just went through that coincidentally at today's meeting. Next slide. So that finishes what I wanted to say about the Brown Act. A very quick overview, especially recognizing I'm pushing into the lunch hour now. So I also want to just talk, I've got 2 slides on conflict of interest laws. This is an area where we could easily talk for a couple hours on this. One of my observations as a local government agency attorney is, unfortunately, this area of the law has gotten way too complicated, which is unfortunate. The conflict of interest laws that we have are vested in a very important public policy of a person cannot serve 2 masters, but when we get into the details unfortunately are very complicated. We have 2 principal conflict of interest laws in the state, the Political Reform Act and a particular provision in the government code dealing with contracts. Significantly, both of these statutes deal with a director having a financial interest. So the focus is on decisions that may affect a financial interest of a director. Next slide. So for the directors, the most important thing in my mind is to be aware of the type of interests to be on the lookout for. And there's many of them, but these are as decisions come to the agency and as you review an agenda of business items coming to the board, you should always have in the back of your mind asking yourself whether any of these business items affect, do you have a direct or indirect interest in a contract coming before the board? Do you have a real property interest that could be directly affected by a decision? Does a decision affect your employer or another source of income? Could a decision affect an investment interest that you got in the community? Could it affect a business role you got as a director, owner, or manager in a business? Could it affect somebody who you've received major gifts from in the last year? And then the last bullet says other personal finances, followed off the screen there, at least on my screen. And so my best advice, without spending too much time on conflict of interest, is to be on the lookout for this stuff. And if you have one of these things, the best thing to do is get a hold of me. I'm sort of the general business lawyer for the water agency to advise on this kind of thing. And one of the things I hate as a local government agency attorney is I get that phone call at 8:53 a.m. before a 9 a.m. board meeting. So if you do have a problem, then get a hold of me earlier. If I have to scramble like that, my advice is probably going to be, well, it's probably safe to say you just better abstain because we don't have time to do the analysis. So just be on the lookout for these things is my best quick advice. Next slide. Yuba Water Agency is what we call a limited purpose special district. You exist by virtue of the California legislature and created by a special act. And you can find that act there. I've got the hyperlink there. The agency act reads as a typical statute. It's very legalistic and not good reading, but it's a very significant document. And it is what we would call sort of your principal governing document. And what's significant is as a special district, you can only exercise the powers and purposes granted to you by this enabling legislation. And significantly, I like to highlight, because you're having a lot of discussions about this of late, the agency, for example, lacks economic development powers. In contrast, five of you are supervisors, and in contrast, the county has much broader police powers because it's under our California's local government rules and laws. Counties are different creatures and they have broader powers. Next slide. So this is the suite of purposes or activities that the agency is authorized to participate in. And I'm not going to read through them. You can read the slide. But as you can see, it's a limited suite of things you can do. And every time you spend money as a water agency, that expenditure must further one of these bullets. And if the expenditure doesn't further one of these bullets, then it is arguably an inappropriate expenditure. And sometimes I feel like I'm, the guy on the agency team who's always having to tell agency staff or the board, nah, you can't do that. That's and I'm as creative as I can be in terms of construing and applying these things, but there are limits. And this is the suite of activities you guys have to work within. And it's important to recognize that the voters created Yuba Water Agency for these purposes. And that's your charge as a director, is to work within these purposes. Next slide. And here's an example of some things you guys have done in recent years, which have been appropriate uses of money. And the first one there is you've participated in certain county road improvements and solar financings. And significantly for that one, you guys sometimes participate in county projects through your investment authority. And that's your authority to take surplus money and you can invest that with the county instead of putting it into a bank, for example. Another project you're working on is the Yuba Watershed Experience Center. That's an appropriate project in terms of a public education and outreach. You're working on forest restoration projects, biomass. We talked about some of the river habitat projects you're engaged in and plan to get engaged in. You provide funding to emergency response providers, first providers that serve the agency facilities and provide water safety in your area rivers. And you sometimes aid local agencies with water and sewer system improvements. Next slide. And in contrast, here's a few things you shouldn't do or can't do. And these are some kind of real world examples where I've been the guy who has said no. You know, there was a thought about granting money to a local community college for a class about forest management, and even though you can do forest management within your watershed, this one, for example, we felt was just too far afield of actual forest management within your watershed. Secondly, as we concluded, you could provide electric vehicle charging stations at agency property and facilities. You couldn't just start installing them county-wide. Another one is you can't do road work or road improvements unconnected to agency facilities or operations. You can't make donations unconnected to agency purposes, and you can't pay for golf tournaments if it's raising money for something unrelated to your principal purposes.
Pardon me, can you go back a slide and discuss the last bullet?
Sure. OPUD and wheatland water system improvements.
Yeah, so is there limits there, or can they do anything related to water and sewer?
Water is the easier one because one of your principal charges is to extend water system improvements for both municipal and irrigation. So that one, you've got pretty broad discretion on the water system side. On the sewer system side, it gets more complicated because you don't have direct sewer authority. You don't have the authority to operate and maintain sewers, for example. What you do have is, and I kind of skipped over this, didn't want to get into the detail point, but you are the SGMA agency, the groundwater sustainability agency for Yuba County under a relatively new statute known as the Sustainable Groundwater Management Act. And in that role, you've got the authority and responsibility to work to protect the groundwater supply and groundwater quality. So sewer system projects are appropriate if we can trace the benefit in the project to protecting the area's groundwater quality. And
can you give me an example of a sewer situation that would not be under our scope?
Yes. For example, if a local sewer agency came to the agency and asked for a grant of a couple $100,000 to replace and upgrade existing sewer mains in an area that was already sewered, that expenditure probably has no linkage to the groundwater quality protection.
So if the sewers were currently in need of maintenance and were leaking and therefore a problem to the groundwater, and that's why they needed maintenance, that would not be in our scope.
For that particular example, it would depend on the information available and the seriousness and ability to document the leakage and the threat to water quality in the ground. If the facts are strong enough to demonstrate that it's a serious leak and it's posing a real and present danger to the groundwater supply, then yes, there comes a time where you've got enough information that you could possibly warrant that under your groundwater protection authority. But that would be a factual specific analysis. Okay, any more questions on this slide?
Nope.
Great. Next slide, Jim. Yeah, and I kind of went through these. These are examples of some of the don'ts. Next slide. And consequences of approving an unauthorized expenditure. Here, the consequences are very serious. If you have what is determined to be an unlawful expenditure, then two significant things can happen. One is the contract or expenditure could be declared void even after the work's been done and the money's been paid to the other party. And on this bullet, there's been some, to just show it's not speculative, there's litigation going on right now in a community in the San Joaquin Valley over school, involving a school district. And I don't know a lot of the details, but there's a taxpayer group down there trying to get a court to declare certain construction contracts as void and to get the money recovered from the contractor. And so these things do happen. It's a rare situation, but it can happen. And then the other risk is when you guys wear your hats as water agency directors, you've got little risk of personal liability because we've got broad insurance coverages and obligations to defend and indemnify you guys. But one of the exemptions is if you approve an illegal expenditure of agency funds. It's one of the few places where there could be personal liability. And again, it's extremely rare, but I feel obliged to let you know that this is one of the few areas where with extraordinarily bad facts, you could be subject to personal liability. That apparently is my last slide. So let me pause here and see if you got any questions. And again, this is a really quick overview on some broad subjects, but hopefully I've highlighted what I view as some of the key issues to be cautious about.
I had 2 questions about the Brown Act, if I can't bother you again. The first question is going back to that social media. It has to be social media about upcoming business, correct?
Oh,
yes. It can't be social media about past business. It can't be social media about a barbecue. It's social media about upcoming business.
Oh no, not upcoming or past, but just agency business. It could be past business.
So if somebody posts past business that has already been decided and is no longer in front of the board, isn't only the Brown Act in referencing anticipatory future business? It is not referencing past business of things that were determined a year ago.
Again, it would really depend on the facts. The past often is indicative of the future, and we reflect on past decisions as sometimes to inform future actions. So it really depends on the particular facts of what's being communicated.
And my other question is serial meetings. I think they're also called daisy chaining. I don't understand how you are responsible for what someone 3 conversations later, who they talk to, when I only talk to one person and they only talk to one other person. I don't understand how someone can be guilty of a crime that they had no control of.
And good question. So it really, if you find yourself in that situation where you're director C or D on that daisy chain, and you get a call from one of your colleagues, and the colleague says, hey, I already talked with director A, B, and C, and they said this, what do you think? A lot of the culpability under the act depends on what the director does then. And a good director is going to recognize that that conversation is inappropriate, and he or she is going to quickly disengage and be done.
Sure.
If instead the director carries on that conversation, that's when, in my view, you violated the act. So,
but if I had no knowledge of a conversation that A and B had, then there is no violation.
Correct. It really takes 2 to dance, and so it takes
so
the person.
Substantively, the breach occurred, but not in a legally culpable way.
Right.
Because all the conversations are the same, but I did not have awareness or knowledge. Okay.
Correct.
Thank you.
Yes. Yes. Any other questions? Well, Jim, it looks like I'm done. I'll let you carry on with the meeting.
Yeah, sure.
You got a question.
Sherry.
Randy, did you have a question?
He's not able to unmute.
There you go. There we are. So, Dick, for clarity in that scenario that we just heard from Seth, if the individual that makes multiple calls is certainly aware that they've made multiple calls, then they are in violation. But the recipient that received the call may not be in violation. Is that correct?
That's correct. The recipient is in violation only if the person initiating the call informs that other director, hey, I talked with directors A, B, and C, and this is what they said. That's it takes that type of information being carried forward. If instead you've got one director just soliciting input one by one with each director, then the only violator is the guy or gal sitting in the middle.
Correct. You also mentioned this is a misdemeanor. So there's up to 1 year to file if there was an action against individuals that could intentionally violate the Brown Act. Is that correct?
I think that's right, but I'm not a criminal law practitioner, so I'm not totally up to speed on my criminal statutes and limitations, but that rings a bell.
Okay. Yeah, I believe that's 1 year on
Yeah.
misdemeanor and 2 years on
Yeah.
a felony. Yeah.
Yes.
Okay.
And again, on there, the risk is only if there's been an intentional, the DA needs to prove intent, which is often a difficult thing to prove.
Correct.
Have there ever been a conviction of a Brown Act violation, ever?
Yes. Not many, but there's been a handful. I've got another more detailed set of slides. I've done on other Brown Act presentations where I've got a slide where I cite to some cases where examples, but very, very few.
And then is it possible to get a link? Oh.
You
cut out Seth.
yeah, a link to.
You may have lost his.
Well, I'm going to assume Seth was asking for a link of some examples of where there's been criminal violations. I will do that, Jim.
Yeah, and we will. I'll post Dick's slides to this agenda item after the fact, so you can go grab those links that he did include. Okay. Any other questions on that? Okay, we will move on to this portion on policies. Terry's going to help me out with the shared screen so I could have my notes on my screen because I only have one computer at home. So real quick, first, you may or may not be, you're probably aware, I've gone over it with some of you at different times. The board policies, these are policies that the board adopts that either apply to the agency as a whole, the board specifically, and they're separated and not determined to be staff level or department level policies, because those do exist as well. So these are matters that come before the board for a variety of reasons. We're not going to touch, there's a total of 14 policies on in the board policy packet, or board policy manual, if you will. We're going to touch on just a few of them, and we'll go through them fairly quickly, and feel free to stop me at any time you have any questions. So we'll start with, these are just listed alphabetically. I'm going to start with a quick summary of the board staff interaction policy. So the purpose of this policy is really to ensure that all elected officials of the Yuba County Water Agency, that's technically our legal term for the name of our organization, that all the elected officials communicate transparently, efficiently, and effectively with the agency's management, employees, legal counsel, other advisors, and consultants within the appropriate chain of command established by applicable laws and board policies, such as this one. Primarily, the policy directs communications from board members through the board chair or the general manager, and the general manager has the discretion to designate an employee to assist a board member in the course of their work on behalf of the agency. It's also important to note the policy does state that nothing in the policy is intended to limit a director's access to information related to the agency's business or prevent any director from asking questions or making information requests to the agency's general manager or staff during a public meeting of the board. So we'll jump to community impact grant and loan program policy. We won't spend too much time on this, but this is a policy that the board just adopted back in October of last year. It includes provisions for grant and loan eligibility, areas of funding, the nexus to the Integrated Regional Water Management Plan, or IRWIMP, you'll hear it referred to as, and then respective application acceptance windows for grants and loans. Board members are, we encourage you to reflect or refer any direct requests for grants or loans that you may have in the community. You know, you're shopping, getting groceries, for example, and somebody comes up to you and say, hey, I want to get an agency grant. How do I do that? So just refer them to me or Joanna Lassard, who's on the call as well. And Joanna we can certainly steer them in the right direction, including how the policy works. It is a fairly complex policy. There's a lot of moving parts to it, so we like to help usher folks who have never done it before. The next one is the conflict of interest code. We'll skip over that. That's something that happens biannually. We update those conflict of interest codes. If you have any questions on that or any other things that I don't talk about today, just let me know. The director harassment prevention training policy, I want to highlight that. It's under California law. The agency directors are required to receive mandated sexual harassment prevention training within the first 6 months from their assuming office. And after meeting that initial training requirement, each director must attend that same training at least once every 2 years for as long as the director remains in office. All right, up next, the director's compensation and reimbursement policy. This policy concerns directors' compensation and the payment of actual and necessary expenses incurred in the performance of duties, official duties. The policy addresses the amount of compensation in the form of a biweekly salary for members of the board and outlines the process for reimbursement of actual and necessary expenses and the procedures for reporting those expenses. By way of example, the agency may cover costs such as registration fees, transportation, lodging, and meals for a board member to attend an aqua conference. It is important to note that California law prohibits the agency from reimbursement of expenses incurred by the director's spouse or domestic partners or other family members, and also prohibited our reimbursement for personal expenses such as charitable contributions, non-mileage related vehicle expenses, the purchase of alcoholic beverages, or personal portion of any business trip. So if you want to tack on an extra day, as a conference is down in Orange County and you want to go to Disneyland for a couple of days, not in the COVID environment, but if you did, we wouldn't be able to cover expenses for that, obviously. For any conference related requests, registration, travel related matters, please contact me. I am the direct contact and support for the board in those respects, and I'll review the policy and any other things that may apply as we work through the registration part. So I'll pause for just a moment. Any questions at this point? For some of you, that those pauses for questions are really just so I could take a drink of water, because got to keep it going. The next one on the list is the drug-free workplace policy. We won't talk into too much detail there. It primarily applies to employees. The energy risk management policy, we won't go into too much detail there. I understand we'll be working on an energy sales report coming up to the board in a future meeting. We may touch on some of the policy components at that session. I do want to highlight part of the ethics policy. That's something that board members touch on pretty regularly. The ethics policy demonstrates the board's focus on maintaining the highest standard of personal honesty and fairness in carrying out duties, performing in a manner that reflects positively on the agency, and supporting a strong safety culture, and meeting the mission areas of the agency. The policy addresses two primary components. That's the state mandated ethics training requirements for directors and designated employees identified in the conflict of interest code. And also the number two is the ethical standards for the members of the board. So it's important to note that ethical standards are also followed obviously by agency employees, including the general manager, and those are provided for in a separate document that's called the Human Resources Policies and Practices Manual. The next three we're going to just touch on real quick. Finance operations policy kind of guides the decision-making process for financial and budgeting activities. You'll hear about that policy and other aspects as the years progress, budget meetings. Those of you who are participants in the ABP committee, it's the administration, budget, and personnel. Touch on those factors. Also, records management policy and the reserves policy. Those are also fairly complex policies. We encourage you to read them. We won't go into too much detail with those today. I did have some notes on the rules of proceeding for the board of directors. Dick was kind enough to cover that in much more detail. That is a great document. I agree with him on the resources and available if you have questions about how a vote might happen. There are a total of 25 rules, and those things are really designed to facilitate public participation during the board meetings, to protect the rights of all the directors, and provide a process for conducting board meetings in an orderly and efficient manner. So if you have any questions about that one in particular, I'm happy to address those. We also have a sponsorship policy. That was just recently adopted by the board late last year. If you have any questions on that one, I'm a good resource. Also, Dee Dee Cordell, our communications manager, kind of fields the processes and the procedures that are related to the sponsorship policy. We have the state of investment policy. This would be an area I think Willie would certainly be able to help with, and Curtis Crawford, your finance manager, probably knows this one by the back of his hand, but we won't surprise him with that right now. So that's all I really want to talk about today. So board policies are reviewed every 2 years. So the bulk of them are scheduled for review in this calendar year. And we anticipate that the substantive updates to any of those policies will first be considered by the policy review committee before they come to the board. And I think that concludes this portion of my item, and available for any questions or comments. Wait, was I muted that whole time? No. Dee Dee, let me try. I'm going to unmute everybody. Now that you might be my.
I was trying to let you know Seth is trying to get back into the meeting.
Oh.
And his tablet died. He was trying to get back in the meeting, so he was.
Well, all right, so I'll start over when Seth comes back into the meeting from the talk. Okay. Sorry about that, Seth. Sorry, I was. There you are, Director. Director, if you can hear me, sorry about that. We can go through that. I was in the presentation. I didn't realize that you weren't there.
Well, sure. You just didn't want me to drag out the meeting any longer. I get it.
Well, no, I'm always happy to answer questions. So
I think it calls for a one-on-one session.
Please support through this whole thing one more time. It's not a problem. Everyone's shaking their head. No, we don't want to do that.
Okay.
I like no questions. That's all right. Anytime.
All right. No questions. Well, that's a pretty high level overview. All right. I guess we would go to manager's report at this point in time, but I think, Willie, what do you think? Ready? He's muted. He can't unmute, Jim.
You should be able to. Let me try something.
Okay,
else.
there we go. Yep,
there you go.
Thanks. I got permission now. Okay. And I don't have it memorized. All right. We continue to operate within regulatory requirements. New Bullard's Bar is at about 517,000 acre feet, which is a little bit less than average for this time of year due to our drought conditions. We've had very little runoff compared to normal to date. Inglebright outflow is at about 726 cubic feet per second. We're in like full conservation mode, trying to save every drop of water we can due to the drought conditions. I got a little detailed summary here of Power Systems revenue. Power Systems revenue for December was $5 million, and we generated about 55,000 megawatt hours during the month. That's 17% higher than forecasted. I've gone over this in the past. The reason why we have more generation right now, even though it's been dry, is because we have to supplement flows from the south and the middle Yuba River going into Inglebright with our storage in Colgate. Therefore, we end up generating more. We also have more revenue and generation because Colgate 2 returned to service 13 days earlier than scheduled. And that's primarily due to a really awesome maintenance crew and the fact that we scaled down the outage due to COVID concerns. The average day ahead energy price was $41 per megawatt hour, which was slightly higher than the prior month. And net Cal ISO earnings per megawatt hour of generation was $59 on average per month this month. And this additional value over the average day ahead energy prices due to ancillary services products that were sold in comparison to our forecast. And that's likely due to the fact that we had low runoff as well. And we had additional ancillary service capacity. Power Systems revenue year to date is $43 million. 9.5 million more than the budget, and we have generated 523,000 megawatt hours year to date, which is 20% higher than forecast. In addition to increased generation, energy prices have been 18% stronger on average than forecast. I will let you know that while we have generated more than forecast to this point, now is the time of year where we should be seeing runoff and we should be seeing additional generation compared to average, where we'd actually have to start releasing water from New Bullard's Bar to manage the flood pool and things like that. So we will very likely see less than average generation kind of February through June. It's just kind of the inverse of what we would normally see on an average year because we're in drought conditions. So I just want to telegraph that we will likely see less than forecasted generation in the coming months.
Aren't we looking at three months of no generation next year?
That would be in 2022, but yes, and that would be during the tunnel outage. So due to COVID-19, our employees continue to work remotely if possible, and all field work is assigned on an as-needed basis with the intent to analyze every job based on need and to coordinate all work to minimize employee interaction to ensure their safety, prevent a COVID outbreak, and maintain an available workforce. I reported 2 weeks ago that we kind of did a reset over the holidays and had almost everyone stay home and try to clear out the minor outbreak that we had and make sure that we all come back in the new year healthy, which we have. And we currently have no COVID cases in the agency. And like I just mentioned, we're really analyzing work on a day-to-day, hour-by-hour basis and making sure that we aren't having people exposed to each other that don't necessarily have to be. The Narrows 1 project, we all know that we just purchased Narrows 1 from PG&E last year. The Narrows 1 license expires in 2026, and the FERC rules require that we file our pre-application documents and our notice of intent to relicense within 5 years of the expiration date. Therefore, our deadline to file those documents is January 31st. We've had our consultants, HDR, preparing those documents ever since we closed the deal with PG&E last March. And so those documents are ready to submit, and we plan to submit those documents on January 27th, which will initiate the relicensing process of the Narrows facility. So like I mentioned, we've seen a very dry start to this year. The first few weeks only accumulating minor precipitation. And in addition, the past few days have seen spring-like conditions, including near record temperatures in the low 70s. We do have an encouraging short-term forecast where there'll be colder and wetter conditions starting this weekend and potentially continuing through the end of the month. Precipitation for the year is at about 40 to 45% of normal. And here's the big one: inflow into New Bullards Bar is only 20% of normal year to date. And that's simply because the storms that we've seen are just wetting the soil and not necessarily running off into the reservoir. We continue to recruit for various open positions. Our HR department is busy in that realm. Broadband, we're currently working with Yuba County and Valley Vision to address the stakeholder outreach planning effort for broadband, which will occur in late January and throughout February. We have identified stakeholders in various sectors: government, education, business, medical, VLL, Air Force Base, and Valley Vision will arrange meeting dates by sector. And Jackie is leading this effort and will be attending all the stakeholder sector meetings for the agency. Post-secondary education, Jackie has also pulled together stakeholders that are members of the career and technical education community, Chamber of Commerce, Yuba-Sutter Economic Development, Yuba College, local trade unions, and business leaders to focus on the workforce of Yuba County. They're working towards effective strategies for increasing post-secondary education with local business opportunities upon graduation. One goal of the effort is to prepare students for high-demand careers in Yuba County with a depth of learning that builds real-world skills. So communications, we launched an advertising campaign on Capitol Public Radio featuring 15-second spots read by the host, with the topic of each highlighting ways we support Yuba County, as well as the state's priorities like forest health, flood risk, fish habitat, and carbon-free energy. We will have similarly themed spots in the Appeal Democrat and our local radio stations as well. Our press release announcing our new board leadership and new board members led to an article in the Appeal Democrat. We also had many mentions in the last several weeks as part of the Appeal's Year in Review series. South Yuba River Citizens League's Wild and Scenic Film Festival is underway. And in addition to our sponsorship of that virtual event, we also have a video being shown during the festival. And this is the one about our fish habitat mission featuring the Hallwood Side Channel and Floodplain Restoration Project. Our upcoming meetings are on February 2nd, where we have a board of directors meeting, an ABP, and a pod meeting. And our clerk, Jim, will be scheduling meetings for other committees in the near future. That's all that I have. Thank you.
Question, do we have any primary way of the COVID shots? Are you an essential industry?
So that's a great question, Charlie. The energy industry through the California Municipal Utilities Association has got together and sent in a letter stating that we think that we should be as high up on the tier or the priority level as possible. They have put us in tier 1C. I think, I don't know what tier 1A are and 1B are, but it's something like, immediate medical responders, then first responders, and then people like us in tier 1C. So that's where energy and water providers are. I wouldn't suspect that we would be getting the vaccine offered to us until, I'm going to guess, late February. I'm not certain about that, but that's what I've heard. So that's the tier we're in, Charlie.
Okay, any further questions, Willie? All right, director's reports. Gary?
Nothing for me today.
Okay. Randy?
Nothing today, thank you.
Okay, Brett's gone. Seth? Any comments? Seth, are you there?
I will try and keep my comments lessened so Jim doesn't terminate me.
I take that as a no. Charlie?
I'll take it next time.
Okay. I think everybody's long meeting. Don?
Yeah, things are starting to come into focus. My questions list is growing, but I'm going to schedule some one-on-one meetings to clear up some things. Thanks.
Okay. That being said, it's up to me, I guess. Just thank you for your support. Our attitude is overcome and adapt, and I'm going to send everybody a 2021 vision statement that I would like any modifications that you would like to add to it as a board member. And I'd like to thank Randy for allowing me to plagiarize it and use it as an input. And that's it. I reluctantly would adjourn this meeting now. Is everybody ready for that?
Hey, Andy, I was going to blame you for such a long meeting for your first meeting as chair, but I think it's our fault, staff, so
Okay.
I'll take the blame.
That's okay. So this meeting is adjourned. All right.
Thank you.
Thank you,
Thank
everybody.
you very
Thank you.
much. Thank staff for a wonderful meeting.
And next time, Mr. Chairman, you go after lunch, you'll have to buy it.
There we go, Charlie. Good job.
There's fair enough. Soldadara steaks.
The recording has stopped.
We can show you how.
Live streaming can be simple and not expensive. You may already have the basic tools right in your hand. But it's more than just pushing live to communicate effectively. That's where Yuba-Sutter.live and Live Streaming YS on Facebook can help you. Make it easy to jump in. Just give us a call at 530-301-2931 or visit our website, www.yuba-sutter.live. Yuba-Sutter's home of live streaming and live streaming tools, live streaming services, technology, and training. Live streaming is Yuba-Sutter.live.